We're discussing how Ed Sheeran is facing a copyright infringement lawsuit with the Marvin Gaye estate, and this has to do with musical works. This has to do with musical works and whether or not Ed Sheeran's music is infringing on the Marvin Gaye. Hello everyone, and welcome to another episode of Tip Top Startups. I'm your host, David Nima, founder of Tip Top Startup Academy, where we empower entrepreneurs, technology startups, producers, inventors, and other innovators with legal due diligence and business due diligence best practices. We discuss trademark law in Tip Top Trademarks, and we discuss startup launch strategy in Tip Top Startups. So make sure you pick up a copy of those books at your Amazon store. In today's blog, we are going to be discussing the copyright laws of the United States and a real-life application of how the copyright law has come into play in a lawsuit for one famous musician, Ed Sheeran. So if you may have heard, Ed Sheeran is in a lawsuit right now with the estate of Marvin Gaye in connection with copyright infringement. And the issue, or the song that is at issue here, is the song called Thinking Out Loud. I'm not going to play the song because I don't want to get hit on YouTube, but you can get a copy, you can watch a copy of it on this blog or just Google it on YouTube, and you can hear this song. And the question is whether or not this is copyright infringement versus Marvin Gaye's, or one of the songs in Marvin Gaye's collection. So in this video, I want to discuss with you how copyright infringement attaches and the due diligence that's required to avoid copyright infringement for technology startups and new media companies. So let's discuss copyright law and kind of how copyright law even attaches in the United States. In the United States, to have a protected copyright, all you need to do is essentially create an original work that fits into one of these categories, okay? This is what's called copyright subject matter, okay? And for something to be copyrightable, it has to be part of copyright subject matter. Otherwise, it can't be copyrightable. Now, in addition to copyright subject matter, it also has to be what's called original, and it has to be fixed in a tangible medium of expression, which means it needs to be written down or saved on a computer hard drive or some other way recorded. You can't just say it out loud and have copyright protection. So essentially you have three requirements at least for copyright protection in the United States. A, it's got to be fixed in a tangible medium of expression, such as a computer hard drive or a piece of paper where you've written down the copyrighted work. B, it's got to be original. It can't be non-original. Now that's a very loaded term in copyright legal circles. You can look up originality when it comes to copyright law and what qualifies as original and what doesn't qualify as original to see whether or not your work qualifies. It's a big topic of discussion that's well beyond the scope of this video, but you just need to know that it's got to be also original. And the third thing is it's got to be copyright subject matter. So these are the various types of copyright subject matter that are protected in the United States. And let's go through, we've discussed examples of these, but I'll give you a couple of more examples here. A literary work is, for example, a blog post, a book, or a movie script, things that are written down. A musical work includes things like the notes to a music piece of song, the lyrics to a song, and the sound recording, when you actually record the song on an 8-track, for example, or a CD, or on your computer hard drive. So those are musical work. Anything related to music is generally protected by copyright law. Anything related to words on a piece of paper is generally protected by copyright law, with exceptions. Then you have dramatic works. These are, for example, plays, essentially. If you write a play, it is protected by copyright law. You have pantomimes and choreographic works. This is, for example, if you have Beyonce and she creates a choreograph for her backup dancers, that choreograph can be protected by copyright law. You also have pictorial works, graphic works, and sculptural works. These are, for example, photos. graphic arts, and in some cases, sculptures can have protection for copyright law. Then you have motion pictures and other audio-visual works. Audio-visual works is just exactly how it sounds. It's a piece of audio that's attached to a moving picture, otherwise called a video. So essentially, most videos are also protected by copyright law. That includes videos on YouTube, and also includes feature films that are watched in the movie theater, and pretty much everything in between. The broadcast on your television, a 15-second commercial, even a 5-second ad on Instagram can be a protected audio-visual work. Then, as we discussed, you have sound recordings, and this has mostly to do with music. And then you have architectural works, and this is basically planning and schema for buildings and whatnot. So these are all the different types of copyright subject matter. Notice, for example, a brand name is not in this list because brands are protected by trademark law. They are not protected by copyright law. For example, patents or a new invention, for example, also not on this list because that is protected by patent law, not by copyright law. So there's a lot of exceptions and exemptions when it comes to copyright law, including copyright subject matter and copyright originality. However, the important thing that I think entrepreneurs can take away is that copyright protection is a type of intellectual property asset in the United States, just like trademarks are a type of intellectual property asset, or what's called a business asset. And you also have patents that can also be an intellectual property asset. A lot of other types of assets, some of which can be intellectual property, others which are just other assets, for example, like equipment for a business. But copyright ownership is also an asset. And this is essentially the surface level discussion of how copyright protection attaches in the United States. You got to have it be in writing or on a computer or hard drive. It's got to be original, and it's got to fit into one of these copyrighted subject matters. For most technology startups, things that you write down, even including business plans and website copy, can be literary works. If you're creating any kind of music, clearly that fits into the musical works. Then you might be creating certain types of videos for your marketing, for example, or if you're a YouTube channel, then you're creating videos all the time. That is your motion pictures and other audiovisual works, also protected by copyright. And then one other part of copyright law that a lot of startups are privy to, but it's not well known, is software code. Software code is also considered a literary work in the United States, and it's entitled to copyright protection. So that's another layer of copyright asset that is available to technology startups. If you want to know more about copyright law, you can go to this link here. Let's just click on it, and you will see some materials related to the full copyright law. This is from copyright.gov, and this is the official website of the United States Copyright Office. It's got a lot of resources here for anybody that wants to look more into it. But I think what you can do is just click on U.S. copyright law and then kind of see the entire download there. There's other sources out there that are available, but really the U.S. Copyright Office also has more outlines available that are shorter that you can review in connection with copyright law and what is protected. Now, of course, in today's blog, or in this blog, we're discussing how Ed Sheeran is facing a copyright infringement lawsuit with the Marvin Gaye estate, and this has to do with musical works. This has to do with musical works and whether or not Ed Sheeran's music is infringing on the Marvin Gaye copyright. And the elements for copyright infringement are only two elements for copyright infringement. You only have to check off two boxes to actually have copyright infringement. The first one is access, and the second is substantial similarity. So access essentially means, in this case, access is already presumed because Marvin Gaye's song, that's the underlying property on which this copyright infringement lawsuit is based, is widely available in the marketplace. Therefore, access is presumed. And therefore, if you're facing a copyright infringement lawsuit, and for example, the work that is at issue, that whether or not you infringed on that work was available on YouTube, for example, or if it was available on iTunes or otherwise widely available, the issue of access will not be an issue in the case because it will be presumed that you had access to the work, and therefore you've checked off box number one, which is access. The next issue is what's called substantial similarity. Now, substantial similarity is very, very complex when it comes to copyright protection jurisprudence in the United States and copyright law. So, substantial similarity is exactly kind of what it sounds like, right? Is it substantially similar to the original work, right? And that's kind of what the judge in this case is going to have to decide, because access is already presumed. So each side is essentially going to have to be arguing on the grounds of whether or not the work is what's called substantially similar. Now, again, lawyers and judges have crafted a whole array of tests to determine substantial similarity in copyright jurisprudence, and that's something that I think is beyond the scope of an entrepreneur or a technology startup to go into the tea leaves in terms of what is considered substantial similarity. You just want to stay away from it, essentially. And again, you can take a cue from the term, the name of the term itself, substantially similar. And if you're finding yourself kind of going between whether or not something is substantially similar to something else, you're well advised to consult an experienced copyright or trade or entertainment attorney that can advise you on the substantial similarity question with the work at issue. But that's usually the hairline issue that attorneys and judges have to decide, which is on the grounds of substantial similarity. So that is a quick overview of copyright protection and how it applies to technology startups in the United States. You want to make sure that you're aware of your copyright assets in your company, and and essentially for anything to be copyrightable, it's got to be fixed in a tangible medium of expression. It's got to be original, and it's got to be part of the copyright subject matter that is discussed here or otherwise in Section 102 of the United States Code, which is the Copyright Code in the federal copyright law. So that's kind of how you get copyright infringement. And for you to sue or be sued for copyright infringement, the issues are access plus substantial similarity. And so those are kind of the spectrums on which you want to kind of think about the copyright layer of your technology startup. Thanks for listening, guys. This is David Nima. Make sure to like and subscribe at Tip Top Startups and share with your friends and family members who are entrepreneurs or are entrepreneur-minded and maybe want to start their own business. At Tip Top Startup Academy, we help entrepreneurs kind of unpack some of the complexities when it comes to trademark protection. And for those that are doing a technology startup launch, we help them with technology startup best practices. We do this with 2 books, Tip Top Startups and Tip Top Trademarks, now available on Amazon, as well as Instagram and YouTube. Follow us at Tip Top Startups. This is David Nima, one of the top trademark and technology attorneys in the country and founder of Tip Top Startups Academy. Thanks for listening, and I'll see you guys at the next episode.